then gathering the primary evidence and opinions related to the issue from the Quran, prophetic narrations, and areas of scholarly consensus, making use of commentaries on the Quran and narrations, the statements of the companions, their successors, making use of collections of narrations which include their statements and legal judgments, the musannafat, classic fiqh literature, including comprehensive texts, collections of fatwa, and region-specific rulings. It includes looking through the legal literature of the 4 extant Sunni schools as well as the other schools. It also includes looking at the decisions, fatwa, and recommendations offered by fiqh councils for previous or similar cases, which we will be getting to in a moment. And it also includes looking at academic dissertations related to fiqh, conventional law, and Islamic economics. If nothing has been found after looking through all of these various sources of evidence or prepackaged ahkam from previous scholars, if nothing has been found, the researcher returns to the basic concepts: justice, benevolence, equity, and the basic legal maxims and default values, and implementing overall objectives of the Sharia. And if the researcher, after using these more meta-level and rational tools, still has not settled on a particular ruling, he begins the process again. And he will repeat this process over and over again because this is a type of ijtihad, and ijtihad is defined as badlul wusa, going through all efforts, expending all energy you can to try to arrive at an answer. If he hasn't gotten the answer, then the assumption is he missed evidence. So he keeps repeating this. But if he keeps going at it and still can never find certainty on an answer, then he abstains from issuing a ruling and he admits, I do not know. That is the general process that Dr. Al-Qaradaghi followed during his own research into bioethical issues. I mentioned earlier that the contemporary jurists work as individuals as well as in councils and a group. Fiqh councils were created to facilitate the evaluation of new issues by pooling the skills and knowledge of senior jurists and by drawing upon expertise from other fields. Consulting with experts from other fields, such as physicians and economists, provides jurists with more accurate information for their evaluation. The councils sometimes attempt to build consensus on existing legal issues and identify which of the acceptable opinions is most appropriate given the current circumstances. The opinions, decisions, and recommendations issued by a fiqh council are non-binding. This is a very important point for people to realize. The recommendations that are offered by IOMS, these are not binding. No person is obligated to follow them simply because they issued them. However, individual nations and institutions, public health institutions, can choose to adopt them as official policies, thus rendering them legally binding. Legally binding because an authority preferred that opinion, not legally binding because a fiqh council arrived at that decision. Muftis can also use fiqh council opinions as a basis for their own fatwa, though they should be reviewed before being applied outside the region where they were originally formulated. The major councils in the Arab world include the Islamic Research Council at Azhar University in Cairo, which was founded in 1961, the Islamic Fiqh Council and the Muslim World League, founded in Mecca in 1978, the Islamic Fiqh Academy, founded by the Organization of the Islamic Conference in Jeddah in 1981, the Islamic Organization for Medical Sciences, IOMS, which was founded in 1984. Similar councils exist in other parts of the Muslim world. For example, in the Indian subcontinent, Southeast Asia, they also have their boards and councils issuing opinions on similar topics. These fiqh councils have researched and discussed a wide variety of bioethical issues. So what are the results of the contemporary scholars? The contemporary jurists and fiqh councils have made great strides towards addressing contemporary bioethical issues. This can be seen in the variety of emerging issues they have considered, as well as lists of overall religious objectives of medicine and the development of professional codes of ethics. Although the codes of ethics and objectives of medicine were not on the list of things I was supposed to look at, I have not seen in English works on Islamic bioethics where people have brought this up. So I'd like to mention them. Jurists have discussed the overall religious objectives, the maqasid of medicine, and they say that they are the preservation of life, the body, its limbs, and considering the preservation of these things a necessity, warding off harms and everything which is harmful, the preservation of health and providing treatment, and enabling mankind to fulfill its role of stewardship. As far as professional ethics for physicians, the jurists have enumerated points which should appear in any professional code of medical ethics for Muslims. And the points include that the attending physician have knowledge, experience, and expertise in his medical profession, that he work in conformance to accepted standards, that he be sincere in his work, trustworthy, and protective of the rights of others, that he know the legal rulings, the Islamic legal rulings and ethical rulings associated with medicine and sickness, that he employ Islamic character and etiquette, including being mindful of Allah, showing humility towards Allah, his patient, and his colleagues, and being truthful and trustworthy, that he respect his chosen medical profession by increasing his own knowledge and staying current, as well as respecting the specialties of other physicians. It includes being dedicated to treat patients, and to never refuse treatment except when legally justified, and to refrain from human testing or experimentation unless having first obtained prior consent, to abide by the laws and guidelines established by the local law, the medical board, or similar authorities, and to protect patient confidentiality. Many of these I know exist in Western or secular codes of professional conduct for doctors, so clearly there is some commonality here. Now, what about the issues that these people have gone through? Well, the individual jurists and fiqh councils have already discussed a very wide number of contemporary bioethical issues. Now, in this slide, I show a large list of things. Now, I pulled these out of a pamphlet that we studied at Dar al-Iftah, and these topics were pulled out of articles that my instructor had put in the newspaper during Ramadan. During Ramadan, they wanted him to talk about biomedical ethics. 30 days, approximately, 30 articles. I have another book by him that has 42, most of which are not here. So these 30, don't think that this is all they've done. This is nothing compared to what the others have. Genetic fingerprints. And by the way, the list here are things that were of interest to jurisconsults, to doctors, and to people in the streets. They might not be interest to Western bioethics, but they fall into the realm of Islamic bioethics. What are the issues that we had during Ramadan? Genetic fingerprints, animal and human cloning, artificial insemination, benefiting from aborted or superfluous embryos. Should I continue the list, or has everyone seen it? Is it enough? Because we're short on time. All right, it's a lot of stuff. I have time?
If you could go through one of the ones that you may think are unique to Islam or distinct.
Distinct to Islam.
With the Muslims.
Abortion is, everyone has like things about abortion that's of a concern. Maybe the answer that Muslims give is different. There's some things, excuse me for it, like hymen restoration. All right, everyone's laughing here, but remember in places like Egypt, this could be a matter of life and death. Right? It might seem really silly to us in the West, but don't we have to take into account the local culture? The mufti has to worry about his stakeholder having risk to life and limb. Right? So that's one of the things that might be fairly unique to Islamic bioethics. Let's see. And by the way, the answers to some of these things might surprise you. When I look at how stem cell research is discussed in America, I'm really surprised at how conservative and strict it is compared to what I would find in the Islamic bioethics things. Anyways, abortion, stem cell research, artificial insemination. Anyways, the whole list is there. We also had the person who put this together gave us a 150-page research paper he did just on human cloning. 150 pages. People probably don't think that there's 150 pages of Islamic bioethics. This is 150 pages on human cloning, and it included non-human cloning also. But this is 150 pages by someone who 10 years ago did a 3-volume book on narcotics and drugs, 3 volumes in Arabic. And it's extensive, and he was writing this, I think, in 92. So before most of us were interested in bioethics, this guy was already there. So there's a lot of stuff. The presentation so far concerns methodological and scholarly matters, but jurists also have a practical role in public society. In addition to the role as researchers and teachers of Islamic legal knowledge, individual jurists take on specific roles to serve the general public. Common roles include serving as judges and as muftis. A judge or a qadi is a jurist who has been appointed by the local political authority to resolve disputes, enforce contracts, protect rights, represent wards of the court, and other duties. A judge's decision is binding. It has to be followed. It has to be complied to, and the person can be compelled to do it. But the roles and responsibilities of judges are pretty much outside the scope of the current topic. A mufti is a jurist who answers questions individuals have about their daily lives. He may also provide special consultation to judges concerning difficult matters. And a fatwa is a jurist's response to an inquiry from the ruling concerning a particular event which has already happened or will happen. Not made up issues, but something that has already happened or is on the verge of happening. Very practical matters. The fatwa is the result of extracting the significant features of an event, identifying a corresponding legal issue in the legal corpus, and then evaluating its validity, whether the essential elements and conditions have been met, and then its consequences. A mufti is a jurisconsult acting in a particular capacity, and the conditions for the mufti are built upon the conditions of a jurist. However, given the mufti's responsibility of contextualization, general rulings, and facilitating the objectives of the Sharia, mufti should have extensive knowledge of the objectives of the Sharia and areas of differences between jurists, and be familiar with the customs and habits of the petitioner's society and the particular circumstances in which he lives. Now this last part about particular circumstances, it means that the findings of the fiqh councils and muftis over in the Middle East or some other foreign land, they might be great there and they might be good here, but they have to be evaluated ahead of time to make sure that none of the custom that went into that ruling is different than the custom here. Anyway. Now, as far as a process, Sheikh Ali Guma, the current Grand Mufti of Egypt and the head of its Fatwa Institute, Dar al-Iftah, breaks this process into 4 stages. And he says that the steps are taswir, takyif, hukm and iftah, or conception, adaption, ruling, and then issuing the fatwa. And the stages of the process work like this. In the stage of conception, the petitioner describes an event and identifies the features of the event which are significant in determining a legal ruling. Based on my limited experience as being a patient, this is kind of like a doctor's consultation where you describe your symptoms and then he starts asking you more things, right? This is what's going on in taswir. The mufti, or the doctor, is trying to get all of the facts necessary to identify what is the problem. And that's what happens in takyif. The mufti identifies a known legal issue that corresponds to the described event. And then in the stage of legal evaluation, or hukm, the mufti checks whether the preconditions and essential elements and associated conditions for the identified issue have been met and its ensuing legal consequences. So for example, suppose someone asks about what is the ruling of getting an abortion. We've collected all of the facts. Well, in order for abortion to be permissible, it has to occur at a particular date or before a particular date. So if a mufti is asked about contextualizing and applying the general rule to a particular case, he looks what are all of the conditions that have to be met. So this is what happens in the hukm stage. And then after that, we get into the stage of response, or iftah, where the mufti then looks at the petitioner's particular circumstances to ensure that applying the ruling will realize a petitioner's interests and promote the objectives of the Sharia. So going back to the example of abortion, usually after 120 days, abortion is not permissible in this school. What if the mother's health is at risk? This particular detail changes everything, because preserving her life takes priority over preserving the child. And then in this final stage involves examining expected consequences. We mentioned this earlier, i'tibar al-ma'alat, which is an essential part of a juris analysis, which unfortunately is often overlooked. Imam Ash-Shatibi discusses this subject in detail in his book Al-Muwafaqat, where he states that a jurist does not judge an action performed by a legally responsible individual, whether it is one of commission or omission, until he has first examined the action's resultant consequences. Now this is pretty important, because if we have multiple ahkam, we look at all of the possibilities, kind of what you do in policy analysis, right? So there's another tool that we can use when we want to get into bioethical rulings. I'm almost done. I'm done at the end. All right. Today, most muftis are trained in a single school of law with some exposure to rulings from other schools and prominent scholars. Muftis tend to issue fatwa according to the soundest opinion in the school that they studied, although circumstances do sometimes warrant preferring a weaker opinion within that school or an opinion from outside the school together. Classical collections of legal rulings include numerous examples. By the way, this is a type of legal plurality, I think is the term you would use. Now, classical collections of legal rulings include numerous examples where scholars of a school acknowledge that circumstances prompt the school's legal scholars to apply a less stringent opinion to ensure that the overall objectives of Islam are met, namely warding off harms and facilitating public interest. Shafi scholars, for example, notice that there's a particular case where a wife, her husband has abandoned her. He cannot be found anywhere. He has not left any money for her to support herself. No one knows where he is. Really extreme circumstances. The soundest opinion in the madhab is that she's stuck. However, scholars in the school point out that if we follow the strongest opinion with respect to evidence, we will be denying rights and benefits that Islam aims as an objective to actually obtain. So this particular ruling, if we were to actually follow it, we would end up getting the opposite of what that ruling would produce had all of the circumstances been the way they were supposed to be. All right? The position I just said, you don't get to use it here. You have to ask a mufti before you can start using that opinion. It's just an example. And alhamdulillah, we have this example. But anyways, the Shafi madhab, what did the scholars do? The soundest opinion is X, but because of the circumstances, we all will use Y. We admit the other one is stronger. Necessity requires, and Islam requires, we go with what, as far as evidence goes, is weaker. So where were we? Institutes and organizations. All right, institutes and organizations often have institutional fatwa policies to address pressing social issues. This is particularly common for official government institutes like Dar al-Iftah, and this is out of acting in accordance to the legal principle that authorities, the actions and decisions of the authority, are to always be there to obtain public interests. In Arabic, we say tasarrufat al-imam manutun bil-masalih. So whatever the authority, whether he's the imam or who takes his place, his decisions are supposed to be there to make sure that the needs of the general public interests, that they are being met. So because of this, sometimes the authority gets to choose one opinion over the other. While classical fiqh books do provide a basis for answering many contemporary bioethical issues, legal research findings offered by contemporary individual jurists and fiqh councils also provide a source for iftah. There's some caveats here. It is important to remember that a fatwa is a non-binding legal opinion. The petitioner is under no obligation or compulsion to follow the mufti's opinion simply because he issued it. He's entitled to go look for another opinion. It is also important to keep in mind that fatwa are intended for individual consumption and that a mufti is not required to document his reasoning and evidence. He doesn't have to do this. One cannot assume that a fatwa found in a classic legal manual or a fatwa collection or yesterday's newspaper automatically applies to apparently similar situations. This presentation introduced the importance of knowing the ruling, the ahkam, for bioethical issues, the relationship between fiqh and medicine, and the need for jurists to investigate contemporary issues. It then presented the role of individual jurists and fiqh councils in investigating contemporary issues, and the need that this be done with collaboration for input from medical experts, and then provided examples of the progress made thus far. It closed with a brief introduction of how muftis apply general rulings to particular contexts. It also included a couple comments about establishing policy that could be used here. And my closing remark is that the substantial work of contemporary jurists and fiqh councils show that the perception that Islamic law cannot address contemporary realities and that Muslim jurists lack a methodology that allows them to engage in and produce viable solutions to contemporary bioethical issues does not match the facts on the ground and should no longer be an issue. Rather, benefiting from their research and inviting their participation should be part of future efforts. Thank you for your time. And I apologize to the next speaker for taking so much of his time.
Thank you very much, Sheikh Musa. Our final speaker is Imam Sayyid Hassan al-Qazwini. Imam Sayyid Hassan al-Qazwini is the leader of the Islamic Center of America, ICA, in Dearborn, Michigan, the largest mosque in North America. He is also founder and spiritual leader of one of the largest Muslim youth organizations in North America, the Young Muslim Association, YMA. Imam al-Qazwini was born in Karbala, Iraq. He studied for 12 years at the Islamic Seminary in Qom, Iran, with a focus on Islamic jurisprudence and Quranic commentary. During his studies, he administered the Islamic journal An-Nibras and authored 2 books, Meditation on the Sahihain, a critique of Sahih al-Bukhari and Sahih Muslim, and a work entitled Prophet Muhammad, the Ethical Prospect. After the completion of his studies in 1992, he came to the U.S. and served as a teacher and scholar of religion prior to his arrival at the ICA in 1997. Imam al-Qazwini is a national figure in the Muslim community, has appeared on a number of media outlets, and has been invited to advise and consult with various members of government, including Congress, the U.S. State Department, as well as multiple presidents. He is most recently the author of American Crescent, a Muslim cleric on the power of his faith, the struggle against prejudice, and the future of Islam in America. It's our pleasure to invite Imam al-Qazwini. His presentation is entitled The Role of a Shiite Imam in Bioethical Consultations. Imam al-Qazwini.
My dear brothers and sisters, peace be with you. Assalamu alaikum. As an introduction to my presentation, I need to point out to the fact that the Muslim community is not a monolithic community. There are 1.5 billion Muslims around the world who are divided into so many sects and schools of thought. We often are asked by non-Muslims on what Islam says about this issue or that issue. Now the answer is, what Islam? There are many schools of thought, there are many sects, there are many denominations. Just as Christians, for example, are divided into so many denominations and sects, Muslims also are divided into so many schools of thought and sects. And therefore, difference of opinion is very, very common among Muslims, just as it is common between non-Muslims as well. But basically, Muslims are divided into two major schools of thought, the Shia and the Sunni. The Sunni school of thought is divided into the Hanafi, Shafi'i, Maliki, Hanbali. There are the Sufis, the Salafis. Also, there are some other groups who might not be necessarily 100% Sunni, such as the Ahiri and Abadi. In the Shia school of thought, we have the Zaydi, the Ismailis, and the Twelvers, the Ithna Ashiris. And it is also very common that you find difference of opinion between the scholars of the same sect and the same school of thought. The Shia community basically represent 20%, roughly 20% of the Muslim community in the United States and abroad. And they are therefore a minority within the minority. Their probably largest hubs are Los Angeles, where there is a huge Iranian community resides, and Detroit. And of course, Dearborn probably is their stronghold. Now, in regard to bioethical issues, there are two guiding principles that rule the fatwas of the Shia scholars regarding to the bioethical matters. The first guiding principle is Shia scholars do not believe in equality of life, meaning that it doesn't matter whether it is a fetus or an adult. The life of both individuals are respected and should be preserved. It doesn't matter whether it is in its vegetative state or it is in its productive state. The life of both individuals should be preserved. There is much emphasis in the Shia school of thought on the sanctity of life. And of course, that's derived from verses of the Quran and the tradition narrated by Muslims from the Holy Prophet and the 12 Imams who are the descendants of the Prophet. Shia scholars believe that there is no justification whatsoever in terminating any person's life. Therefore, for example, they take a very hard stand with abortion. They believe that all forms of abortion are prohibited and there is no justification for abortion. Probably the only situation that is deemed permissible is what my brother Sheikh Musa referred to, and that is when the life of the mother is in danger. So now you have to choose between two lives, the life of the mother and the life of the fetus. In this particular case, Shia scholars believe that the mother whose life is in danger then can abort the fetus. But other than that, Shia scholars do not tolerate terminating someone's life. The other guiding principle that rule in the bioethics, Shia bioethics, is that we have two types of predestination. And Dr. Jackson briefly alluded to that. From the Shia perspective, we believe that there is the definite predestination and indefinite predestination. Al-qada' al-mahtum wal-qada' al-mu'allaq. Definite predestination is like someone who is cancerous and he exhausted all means of treatment and there was no treatment whatsoever left for this person and he would die. This person will face death by God's predestination and he has no role, he has no hand in his death. For he exhausted all means to survive and he could not. So if he dies, it would be with God's will.